Hello, Heather and Sarah. Thank you so much for joining me. We're recording this on a weekend, so I really appreciate the fact that you're taking the time to do this interview with me and Sarah. I'm happy to see that you're feeling much better. You were a bit sick, so it's good to see you that you're good here now today. And I'm very excited about this interview because this is after a big win for both of you ladies. So congratulations. This is the Bykovets case out of the Supreme Court. This was a big case. Everybody, all the defense lawyers in the country were talking about this case. This is really a big deal, one of the big wins for the defense in a long, long time, the Supreme Court, and in a very important topic, which is the IP address. I don't want to talk too much because I really want to hear from you ladies. Bykovets was your client and you were with him since day one until the very end, until this very great result at the Supreme Court. So I really want to give you this opportunity to tell us all about this case. I'm sure everybody wants to know everything from the factual background to what happened at the Supreme Court and the arguments that were made and where this case is eventually going in the future. So, Sarah, I know you were trial counsel, and let me just say, Sarah, you're a WiCCD member, you're a VP of WiCCD, so we're very proud of you and very happy that two females were really representing and who won this case. So, Sarah, as trial counsel, maybe you're in a good position to give us some background information about the case, the facts, and then we'll slowly get into what happened at the Supreme Court.
Absolutely. And thanks so much for having us. We're pretty excited to talk about
My
this
pleasure.
does for the what it does for the law in Canada. The factual background of this case what related to some online purchases that were made with what police suspected or the retailers suspected were credit cards used without permission. And the purchases were made on a website that used a third-party processing company to process their online purchasing information. And so police, when they were contacted that processing company and asked for the IP addresses associated with the purchases that were of concern. And the core of the issue that ultimately took the case to the SCC was that the processing company provided those IP addresses for all of the purchases without any need for authorization. They simply turned them over to police. And that was the basis of police ultimately getting a search warrant and obtaining some evidence that became an issue at trial.
All right. And then at trial, that was at the trial level, but then obviously like this matter then went all the way up to the Supreme Court. And at the Supreme Court, it was really one issue that was the focus of the whole decision. So let's get into that and what really happened then at the Supreme Court. And this is where Heather also got involved. That's my understanding, right, Heather?
Yeah,
Yeah,
absolutely.
that's right. Or at trial and at the Court of Appeal, it was Sarah and my partner Ian Mackay who represented Mr. Bykovets, and then I came on in the Supreme Court level just for this single issue. And so the case took a little bit of a journey through the Supreme Court. Initially, we had a hearing around the beginning of January of last year, and that was a court of seven. It was a fairly spirited panel, as I recall. My memory of it is limited because both Sarah and I were very sick at the time. And so in addition to being on camera with the panel of judges being surreal to begin with because it's all happening through a computer, we had that added feeling of having our heads completely underwater due to our illness. But we made it through. Actually, for any junior members of the bar watching, it is a webcast worth checking out because you can see that a difficult day can lead to a change in the law that we're proud of, because in addition to the issues I've mentioned shortly into my submissions, my tech inexplicably went completely dead. And so we had, juggling headphones, and it was just a disaster. But we made it through. We answered the questions as I understand it. And then the case was on reserve for quite a while. And with the departure of Justice Brown,
Mhm.
who was on our panel, we were sort of wondering what was going to happen with it. And then we got word late last fall that they were going to be doing a rehearing with a full court. And so the rehearing, which I've never experienced, happening in one of my cases at the SCC, they just advised us that they would be reviewing all the materials, watching all of the submissions, and if they had questions, they'd let us know in writing. And so we never did receive any questions, but the rehearing took place. And then, of course, the decision came out just last week or
Yeah.
whatever it was. So that's the Coles notes of what happened at the Supreme Court. And, both I think every justice participated. I can't quite recall. But both the appellant and the respondent had numerous questions from the bench. They were very engaged, and clearly this is one of those cases where the court really had the opportunity to engage with and grapple with the question of, okay, what kind of world do we want to live in when it comes to the contours of the informational balance between the citizenry and the state? And so, from my perspective, that was sort of what it boiled down to in terms of what's at stake with an IP address.
Yeah, well, I mean, there was some very strong language in this decision on the importance of protecting information, digital information on the internet, which is, I mean, we haven't seen that kind of strong language in favor of individual rights in a long time, I think, from a Supreme Court case. So, and it seems almost like the Supreme Court is giving a lot more importance and value to digital rights and information more so than to the physical one. But I mean, before we get to what the implication of this case is, let's just go back to the issue then that you argued at the Supreme Court. So maybe both Heather and Sarah, if you can weigh in on this and share with us what happened, the argument itself at the Supreme Court level.
Yeah, so the case went up on a dissent from the Alberta Court of Appeal, and the single issue that took it to the Supreme Court was whether or not an IP address attracts a reasonable expectation of privacy, whether that's information police can obtain at any time for any reason, or whether or not they need pre-authorization, a minimum threshold in order to get that information. And so, one of the sort of central issues or debates that became a part of that is, what does Spencer, oh, my co-counsel is joining us, maybe not. What the sort of extent to which Spencer already addressed this question, or whether
Not to interrupt, but it was the cat, right?
Yes,
because your co-counsel is here.
Sorry.
Okay.
The cat was debating joining me on camera.
Okay.
One of the sort of issues that structured the way this got addressed at the Supreme Court was, how far does Spencer go? Has Spencer already decided this? And to a certain extent, our position was, it has by implication. The information that's at stake in Spencer is very similar to the information that's at stake here. It's sought in a different or a particular way in a Spencer context, but the question of whether or not connecting an internet user to their activity and their identity is private, Spencer answered that question, but it turned out a whole lot of potential for disagreement about whether or not that was the case. And so that was the sort of thrust of the debate between the parties at the SCC and the basis for a lot of those spirited questions that Heather referred to.
Right. And there was a distinction that was made between Spencer and the case here. So maybe if we can get more into that, like I think this one goes a bit beyond or adds more to what is covered in the Spencer case. So if we can talk more about that.
Yeah, well, the one of the things that's really interesting about this case is it involves a fairly complex test, right? And just to back up, Section 8 of the Charter protects everyone from unreasonable search and seizure. And whether or not Section 8 is engaged is settled with reference to a four-part test that can be found in the decision for the lawyers who are interested. But it is a very nuanced, nuanced and can be quite complex in terms of whether you find a reasonable expectation of privacy in any piece of information or thing seized. And so part of the debate is when you have a test this complex, there's a lot of room for how you look at it, right? And so with, Spencer, like Sarah
Mhm.
was saying, the issue is, well, if you step back um, and you look at it in that case, subscriber information. Well, for those familiar with Spencer or unfamiliar with Spencer, it actually wasn't Mr. Spencer who held the account in that case. I think it was his sister. And so that wasn't a barrier to saying, well, no, what they wanted substantively was to link Mr. Spencer to the activity, right?
Mm.
And so you go through this four-part test with its sub-factors to sort of determine whether or not a reasonable expectation of privacy is engaged. And so that same test is at issue or is the operative analysis when it comes to an IP address. But you do it all over again and you look at a number of the same factors, what role does your control over the information play? One of the things that came up here was that the service providers can change the string of numbers that makes up your IP address. Does that matter? To what extent? What's the role of third parties? All of that kind of stuff. And so yes, this case stands for IP addresses attract that expectation of privacy because of their enormous potential. But it also stands for sort of the attitude that we're going to look at these things, right? And the way that we're going to look at these things is based on the technological realities that face us, right? Like in the majority decision, they talk about, the internet being the most vast cultural artifact that our species has ever created. They talk about how IP addresses, when you view them in terms of the power of data in aggregate, they're enormously powerful, right? And so applying that lens, they're really encouraging a more robust view of privacy and of the analysis in this area than, oh, well, don't be so concerned. It was just a string of numbers, oh, don't be so concerned. This is just a step to getting a Spencer warrant that they need to take. And in the oral argument, I think it was in the oral argument, um, Sarah made the point, or someone made the point, well, no, their stated purpose is not the operative part of the analysis here. With the right amount of data, this can serve as a vehicle to sidestep a Spencer warrant altogether. right? And so it's a little bit more, yes, it builds on Spencer in terms of IP addresses, but it also reinforces that holistic view of, what is the normative expectation in the society we actually live in, right? I can't believe my lights turned off.
So, sorry, we just had to come back after Heather had to fix a minor technical issue, and it seems like the technical issues that you were having with this case are still happening whenever you're dealing with the case of Mr. Bykovets.
Story in
Well, my
various
power is
situations.
restored, and Sarah tells me that authenticity is critical to existing successfully on the internet. And so we're getting a bunch of authenticity this morning in terms of the realities of my technological
Why
existence in this
privacy
case.
is so important. We're our real selves on the internet. And I mean, to pick up on what Heather was saying in terms
Mhm.
of the expansiveness of how the court talks about this and the way that they, like, I still think that one way to make sense of this issue is Spencer decided that we have particular rights online, and it applied those in one specific context where those warrants are
Right.
appropriate. And this was a case that noted, okay, there are other cases where that similar set of issues is at stake that aren't covered by Spencer warrants.
Mhm.
So we need to acknowledge and protect that same information, that same risk, where Spencer warrants aren't going to do the job. And one of, the majority sets out, here are 3 reasons that Spencer doesn't cover everything and that this information is totally dangerous before or in situations where a Spencer warrant wouldn't apply. Um, but I think one thing that the majority goes out of its way to do is put this in context of the last 10, 15 years of digital privacy
Mhm.
decisions, right? There was a way to make this decision that was quite narrowly explained, if expansive in its application. And the majority does not do that, right? Every single point that the majority makes, they are drawing it back to where they have said this before, where they have given us the interpretive principles, where they have set up the thought structure that would help us, make clear in applying it in different factual contexts what the values are that are at stake, what the way that we should interpret these issues is. They are putting, this is a citation rich decision.
Yeah.
And I think that is extremely deliberate, and forward looking in a lot of ways, because much of what the court gives us here, it has already given us, but there is something, the medium is the message, in the sense that the clarity and the emphasis, and the way that they're pointing out, we have been consistent on this. This court has changed a lot in the last 10 years. The composition of this court is much different than it was in 2012, 2013. The principles, the holdings, the rules have not changed. These are Canadian values and are rules that we have consistently held up as essential to the democracy we want to live in, and what we think we should be able to do. And I think that, beyond the application of the rule in this case, the way that it's presented by the court is its own extremely strong message here.
Well, I mean, that's what makes this case really exciting, right? Like the decision is very interesting to read because there is some very strong language on the importance of protecting private information, especially in the digital world. And it's nice that the court here is saying that, okay, fine, we do have Spencer, but no, we have to go beyond. So it seems like they have this openness to still go beyond and protect even more this type of information. So I have a few questions here. Like one of them is, so does that mean that digital information, it seems like for this court, has more value, is more important, and we need to protect that more than physical privacy or expectation of privacy in a car, which is always referred to as reduced and not as important as other types, although I personally disagree with that, but still. So there's that.
Now,
And
very interested in what it is that you have in your car. Um, if we can, yeah, if I can just respond to that, I think it's a couple of things. I think there are, if we look at the way that they do this purposefully and sort of functionally, if you can make the analogy to physical space from digital privacy, information is information. And, they've made clear again, we're not getting hung up on categories and rules and definitions here. We're looking at function. And so the question is going to be, what does Maya have in her car, and why does it need protection? But I also think that there is something, the court makes the point here, and it was in Maraca, it's through a bunch of decisions that we do things online that we don't even do in our houses, right? People are having conversations, they're sending messages, they're looking at things they don't own in books, that they don't say to their spouse, that there is even within the privacy of your home, even more private things are happening on your phone. And so there is a potential for like the way that we can be revealed and exposed, and that we're exploring and discovering ourselves and establishing ourselves and connecting. The internet is unique in that way. And it is, where the analogies are appropriate, I think privacy is privacy, but also their particular attention to digital privacy is justified because it does something that no other medium or experience or method of communication does, and it does it all at the same time together. And it is so important and also so dangerous in the hands of people that you have not chosen to share that with.
Right. No, I mean, it is definitely very important, especially that the digital world is still evolving. I mean, what we can do now on the internet is a lot more than what we were able to do 10 years ago. So it's great, I think, that the court is alive to that issue and that they seem to be willing to protect our digital information. So, but then where do you see this going though? Like, first of all, like, let's start. So does that mean that now we will have a Bykovets warrant? So are we going to have more types of warrants? What's going to happen?
I mean, maybe. I think that when we have requests for IP addresses, certainly the law enforcement will wish to turn their mind to getting a production order, or risk inadmissibility on whatever's gathered. But I think, sort of like I was saying before, the question is settled for IP addresses, but to the extent that other pieces of information are being seized from third parties, doing that constitutional analysis in terms of whether or not an expectation of privacy is engaged may be more front of mind. Because, one of the important things to remember is it's not as though the tools aren't out there, right? A production order is not difficult to obtain when you have the requisite grounds, which is a reasonable suspicion standard. And I think the majority points out you don't even have to go anywhere to get it. Telewarrant provisions mean you can fax it in. And so I think this decision will hopefully encourage more pause and reflection on privacy prior to seizing information, even when, upon request, a third party may hand it over, right? And that's one of the important parts of this case, is again coming back to that issue of just because something is in third party hands does not mean that it's been abandoned, or that privacy in relation to it has been extinguished. It's one factor of many in the analysis, but just because you can get someone to turn something over does not mean that it is not necessarily an information seizure for constitutional purposes. And
Right.
that's kind of an important part of this area of
Yes.
law right now.
It is very important. And I actually, on this point, which is a very important point here that you're making, Heather, because that's the problem, I think, with the internet and online activity is that we are giving up information without necessarily being aware of that. So like, we don't know what people know about what we're doing. I mean, we know that they do,
Right.
but
Yeah, and that's an issue that's really, really important because it also sort of exists, across society, right? And so
Mhm.
having the analysis be focused on the information itself and the potential of the information means that the right belongs to everyone, right? Some internet users may not understand what VPNs are or how they work or, pay for the subscription that you need for some of them or whatever. Some people, maybe they only get their internet when they go to McDonald's or something like that. And, when you're in those situations, you may not think twice because you need to do your banking,
Mhm.
right? You log on to the hotspot that's there or whatever it is. And, somewhere deep in the depths of the fine print, I'm sure there's, things to do with sharing that information that ultimately leads to the data brokers that have the billion-dollar industries or whatever. And whether or not you know enough to take all of the precautions you would wish to with your own information really just can't be the test about whether or not you have rights, whether or not your information's private and is worthy of protection, right? So this judgment says, look, all of our information about this is private. It's worthy of protection vis-a-vis the state.
Right. And Sarah, did you want to add anything on this point that we were just discussing right now?
I think Heather has really captured it, that both that it can't be that your level of sophistication, your level of knowledge or ability to protect yourself proactively can't be what determines your rights, and the court's very clear about that. And that you don't have to give up being online, right? You don't have to choose between existing in
Right.
the modern world or having these, the experiences where you find like-minded people, or, you've not shared an aspect with your identity with people in real life, but you found a community to support you online. Like, you don't have to make those choices to protect your privacy. And the language in this decision, particularly around that we cannot delegate the protection of this or the decisions around this to third-party corporations. This has to be a rule that governs state actors and what state actors do, and is the same for everybody. It's critically important if we're going to have an internet universe where people have a comparable ability to, you know, reap the benefits and participate and function. And there are certain banks that just exist online at this
Yeah.
point. Um, and it is heartening to see the court so clearly supportive and so emphatically clear about what we don't have to compromise to participate in society in that way.
And, another point that's, I think, important to sort of come back to when we're talking about these kinds of cases, this area of litigation, criminal litigation, it's where these contours are defined for everybody, right? And so, you know, it's it's the rights that build our civil society, not just for every internet user, but also for the areas, institutions, and people in society that are critically important to a functioning democracy. You know, like sometimes when I'm having these discussions, even though I try to avoid them, we get that sort of, well, they can look at my phone. What are they going to find in there? And it's like, well, Auntie, you're not a journalist, you know, like you're not, are you a politically active protester organizing really important thing? No, right? Of course, they're not going to find anything in there, but there are people for whom they will. And that point, um, is made in the majority decision or recognized where it
Mhm.
says, well, no, what's at issue here is not the stated purpose, right? Is not we're investigating some frauds on the co-op, and so that's good. What's at issue here is can these things be collected in aggregate by the state for any purpose, right? And so part of what is engaged in this area, and it's almost always criminal cases that bring it to the court, but part of what is engaged here is really the extent to which we will tolerate mass surveillance given the technological realities that are possible with the right software tools, you know, and we've got examples like the whole Clearview AI thing in terms of scraping the internet and you know the RCMP investigation. Well, I think it was Project Citizen to do with Facebook data and things like that. And so the state can buy these tools that make automated data collection just a different beast than what we're dealing with in terms of, you know, if someone got a hold of an elderly family member's phone or something, right?
Right.
Yeah, I think that the one of the points that we return to over and over and over again in this litigation all the way along is that recognizing a reasonable expectation of privacy does not mean information is never available to the state. It means that we've collectively, through the court, come to a minimum threshold before they can get access to it, that they're not the sole arbiters of when this comes into their hands, and that it needs to be subject to scrutiny and evaluation by judicial bodies that we have given that authority and whose judgment we rely on for it. And so it's not a question of never letting
Mhm.
authorities have it. It's about ensuring that they only have it in the situations where we think that it's appropriate and where the balance of all of the competing interests means that it's justifiable and necessary.
Yeah, and in many cases, they probably will get that information eventually. But it's like you can't just get it just like that without justification. I think that's the ultimate point here. It's like you have to explain why and how this is important, how this is more important than protecting an individual's privacy. So, I mean, for the public or anyone who's maybe not very familiar with criminal law watching this, it doesn't mean that the police will never have that information. They will probably end up having it, but it's not, it just makes it a bit more difficult for them to get it.
Yeah, and more limited and subject to sort of transparent scrutiny
Yeah.
when they're able to get it.
Yeah. I mean, it seems like we're very much okay, or society is very much okay with that when it comes to sex assault cases, that it's very difficult to get complainants' information. But then when it's an accused, it seems like it creates some kind of different reaction that no, you should get easily that information. So no, just like um, we have standards when it comes to one side, it also should apply even more, I think, in the context of an accused who's facing the potential of a criminal charge.
Yeah, and I think the point that Heather made earlier, right, which is these come up in criminal cases on the particular facts, but what makes them such an issue is that it's not ever just the accused information when we're looking at
Hmm.
recognizing the reasonable
True.
expectation of privacy. It's going to be, it's a societal wide interest that we're wrestling with. And
Yes.
so I think there is often, um, you know, it's a mistake to look at this we've got content neutral rules in the search context for a reason, right? That the court does not look at, well, do you have privacy in your criminal plans? We look at, well, do you have privacy in your home, right? Whatever you're doing there, good, bad, we need rules that are blanket and clear and equal for all situations, because that's how we build a democracy. And so we often, to the extent that we often struggle to see the humanity of defendants, it can be, a risk in privacy cases if we look at them in terms of what is a defendant entitled to, rather than what minimum threshold do we want to set for our state in all similar circumstances, because that's the rule that's getting hashed out in cases like this.
Yeah. No, it is definitely a very important case. And what was very interesting is to see how much the court was very aggressive on defending those rights. So that gives hope for other lawyers in future cases that there is chance, because it's important to feel that there is hope. And this case really gives a lot of hope. And honestly, you ladies did an excellent job. We're all very happy and proud of you. And thank you so much for taking the time here today to do this interview. We're very thrilled to have you as guests. Heather, it's the first time, but hopefully not the last time. And I'm sure you will have lots of amazing cases in the future. I don't know if you already have something in the Supreme Court that we'll maybe talk about later on. But I really want to thank you so much and congratulate you on an amazing job. This is important, not just for you, your firm, your client, but for the whole nation. Everybody will. And this is, I think the nice thing also is that this is one case that people can't say, why do you guys, defense lawyers, do this type of job? Like, this is important for everyone, for every Canadian citizen to know that their IP addresses are protected. So it's really important work. So congratulations and thank you again for doing this.
Thank
Thanks so
you for
much
having us.
It's my pleasure.